So that's to make the point, this is not like the food stamp application. You don't have a choice with the food stamp application. With discount rates, there's also some glitches because it's hard for the companies to get everything on the forms. I'll explain why when we get to discount rates. If there's something wrong with the form, figure out an end run. Here the end run is you don't need to use their form. Just get the letter from the doctor. Don't wait for the company. The letters, again, the samples were on page 87, I believe. Yeah. Let me say a few things. It should have the name of the patient, obviously. It should have the address, because if it's a household member, not the customer, you've got to be telling the company someone who lives in that household at that address. Then there's it should definitely have the word serious illness in it. If it's a chronic illness, it should definitely have the word chronic in it. And then there's one other thing, that there's two interpretations. Does the doctor actually have to describe the illness? Which maybe there's HIPAA issues, finance. You're nodding your heads no, that's my position. What the reg says about the letters, it shall describe the condition or something like that. To me, legally, there's two kinds of illness conditions. One is chronic and one is not. So if it's chronic, you have to describe it by using the word chronic. I don't think the letter has to say you have whatever you actually have. And because the letters are presumptively valid, that is, once the letter goes in, it's presumed to be valid, the company would have to push back. So if you have a client who doesn't want to disclose it, you have a doctor that doesn't want to be putting that stuff in a letter that's going to a utility company, I'd say follow the bare minimum. State the name of the person, what their address is, say that there's a serious illness, make sure it's on the right letterhead of a doctor, nurse practitioner, or physician's assistant, and see what happens. And if you hit a wall, let me know. Okay, so we've...
I was going to ask that if mental illness is one of the issues,
yeah,
that would be a case in point that I'm treating Ms. Ramos for depression. Is that something that should be said in a letter?
My feeling is if your client, the patient, doesn't mind, it could go in. If your client minds or the doctor minds, it shouldn't go in. I think it's a personal choice. So what I'm saying is I don't think the law requires you to do it, so therefore it's up to what the patient wants to do in consultation with the doctor. You don't have to put it in, I don't think. And if you hit a wall, let me know. Because I suppose, I haven't told this story in a while, but you remind me of it. So there's a company, again, in your service territory, but I won't name, and we were tussling about this very issue of when was a letter good enough or not. And so I got a call directly from a guy, I'm assuming in his 50s or 60s, who had diabetes and peripheral neuropathy. Now, I'm not a medical expert, but I have a dictionary in my office, so I found out that peripheral neuropathy really means your legs don't work, because that's a very common condition with diabetes. In fact, the guy was calling me from his own car, which he was no longer able to drive. His son had to drive him anywhere he had to go, and he was on the way to the doctor because the peripheral neuropathy was bad. So he gets a letter from his doctor, and sometimes the doctors, don't have the time to do it exactly the way we suggest, or sometimes we didn't tell them to do it right. So the letter says, please be advised, my patient has peripheral neuropathy and diabetes. Please don't terminate his utility service. And the company was going to shut him off because it didn't have the word serious illness on it. So I called up the credit and collections manager of the company and said, you're going to shut off someone who has diabetes and peripheral neuropathy? He says, well, my employees don't know what peripheral neuropathy is. And I won't use his name, but I do remember him well. I said, get out a dictionary. You know what it is. Yeah, but it doesn't have serious illness. Well, believe me, that guy didn't get shut off. And we aren't seeing those kinds of problems. I only tell the story. If you see that kind of problem, let me know. If they say, it said serious illness, but the doctor wouldn't describe it, tell them go fight it out at the department. They can't shut your client off. Okay. There's a couple of other things. Don't let me forget to talk about financial hardship, because if you got your yellow sheet, it says I not only have to have a serious illness, I need financial hardship. A couple of other things about doing it quickly. So we covered that you don't want to wait for them to send you the letter, because it's going to take too long. You can fax things in. Now, a couple of cautions there. The experience has sometimes been that faxes to these large companies just get lost. So if you do fax it in, please save one of those confirmation sheets. Because on the one hand, it's going to get there a lot quicker. You don't have to worry about how long is the mail going to take. On the other hand, you don't know who's going to pick up that piece of paper and whether it goes to the right place. So there have been a couple of companies where this has been a problem, and I don't think it's an intent problem. I just think these are big organizations and things just don't get through. So if you had faxed something in and your client's about to get shut off, I'd call the consumer division of the Department of Public Utilities and say, I've got a copy here. I don't know why they don't have it. I'm going to fax it to you. Tell this company not to shut my client off. Here's a great example, by the way, of something I also will mention 3 or 4 times in the training. Go to the consumer division when you're not getting the right result. This one, you'll almost always get a good result. If you can prove that you have some kind of documentation of serious illness, and somehow the company can't seem to find it, call the consumer division. They'll usually make sure the account is protected until the paperwork sorts out. And that raises another point about how to quickly protect your clients. Do most of you work here at Project Hope? How many work at Project Hope? Anybody else? Tell me where you work. Anybody? What? Great, okay. So those names, if you work at NSTAR, you've heard those names before because these organizations have called. My experience is, if for some reason you can't get the doctor to do something quickly enough and you call them and say, you know what, I'm working with that client, they really do have a serious illness, I can't get to the doctor's office, could you please give me 3 or 4 days to get that serious illness letter in? It'll often work with the company, and it will almost always work if you go to the consumer division. The consumer division doesn't like seriously ill people to be shut off. And they get it that some days you just can't get the paperwork together for various reasons. So be very assertive about this. There are a couple of things in the regs that guarantee that it happens quickly. So I'll tell you 2 things that are in the regs, and then there's a hole in the middle. If a field collector is actually at the house about to shut off service, they are supposed to go through these rights: infant protection, serious illness, probably those 2 in particular, elderly. And if your client, the customer, says, oh, you know what, yeah, I have a serious illness, the person has to not shut you off and give you 7 days to get the documentation. So that's one clearly covered by the rules, instantly stops things. Second one is if the doctor or nurse practitioner or physician's assistant calls up the company, the regs say you get 7 days. So the doctor can call and say there's a serious illness, I don't have the time to write the letter right now. The whole, and I was speaking to that a moment ago, the whole is, well, customer can do it, doctor can do it, you can't. No, the reg is silent on that one. But that's why I think the department is so willing to order the company to lay off for 3 or 4 days, because the customer could do it on their own, doctor can do it. You're an advocate speaking to the client. You may have already spoken to the doctor's office, but you're going to need to be a little assertive on that one, because the regs don't guarantee that you can ask for the 3 or 4 or 5 or 7 days and get it. Okay, folks, follow me on that? You can. So now I want to tie this all together, and don't let me forget to talk about financial hardship. You can literally stop the truck in its tracks. Sometimes I've had the call, and it looks like that person's going to be shut off that day, and I call someone at the company and say, it is scheduled for termination that day. I think the truck may have left the yard. If you assert serious illness protection properly, they have to stop the truck. And the other one I've done more than once. I always love this because I go home and a lot of the other stuff I do, I don't know what I'm doing and if I'm succeeding. But this, you know what you're doing and you know if you're succeeding. I go and say, Eliza, I got that service restored within 2 hours of my call. So I've had calls at 3 in the afternoon. The person is shut off, proves serious illness, and it's on by 7 o'clock that night. So I'm not going to guarantee it always works that quickly for you. I know the right people to call. I'll fess up. I do know the right, but the department's expectation, the consumer division's expectation is basically you get restored within 24 hours. Unless there's a snowstorm, obviously all the employees are tied up restoring power, or a thunderstorm just blew through or something like that. But when you call up and your client's off and you're trying to get it restored, your expectation should be about 24 hours, and if they're saying something different than that, you would want a really good explanation of why it's anything different than that. So that, don't let me forget to talk about financial hardship, but there's one more piece on the serious illness side of it. So the reg says, no electric or gas company may shut off or fail to restore utility service when there's a serious illness in the household and a financial hardship. So it's kind of obvious what those words mean. You can't shut someone off. What does fail to restore mean? I can tell you the clear part and then the murky part, which I keep hope. I just saw Liz Salucci yesterday. I'm still not sure it's resolved. So if you go back to, some of you who work in the building, if you go back to your office later today and someone calls up and they got a serious illness, you're going to get their service back on if you can document it. If they were shut off in the last day, certainly the company will say, okay, now that you told us there's a serious illness and you documented financial hardship, we'll turn them on. If they've been shut off for a week, you're probably almost always going to get the service restored.